2340 JB Capital Management LLC. And that is a request for a series of variations on a certain property, which is in Downers Grove Township. It's comprised of about 2.3 acres. And the matter was published in the Daily Herald on June 26, 2023. See, I have no objections from building. DuPage has no jurisdiction. Health Department, Stormwater Department, Public Works Departments. Burr Ridge has not submitted comments. Neither Downers Grove Township. Township Highway Department has no objections. Tri-State Fire, no comments received, and Forest Reserve, no comments received. I'll recognize Mr. Roth on behalf of the petitioner.
Thank you, Mr. Chairman. Good evening, members of the board. My name is Michael Roth, spelled R-O-T-H, and I am an attorney representing the petitioner, JB Capital Management LLC, in this matter. With me tonight is also John DeYoung, who's the president and owner of JB Capital Management. I would like at this time, with your permission, to offer into evidence. I have a packet, and I will read into evidence what that is. I would also like, if I may, to circulate identical packets for each of the members of the board.
Okay. Take those as your exhibits, and we'll mark them as you.
So should I give Jess?
Yeah.
Thank you.
Is anybody on any board members present by Zoom or telephone? No. I should say that Mr. Murphy and Mr. Schultz are not with us at this point. All the other members are present.
So, if I may, I'd like to just read into evidence what it is I'm circulating and what I have offered into evidence. And so they are. First, exhibit 1 is a plat of survey for the subject property of the application. Exhibit 2 is what had been entitled previously as a subdivision plat. Although at this point now, we are not going to be requesting subdivision, we are going to be requesting an assessment plat. This would serve, I think, for purposes of the hearing as our site plan, and it will be presented and, if approved, recorded as an assessment plat for the subject property. Number 3 is a vesting deed for the entire subject property, showing ownership in JB Capital Management. And then exhibits 4, 5, and 6 are ground level photographs of the subject property, to give you a perspective of what the property looks like at ground level. And then exhibits 7 and 8 are aerials of the area, the neighborhood of this property. Exhibit 9 is, I guess it's an exhibit, but it's the zoning application that we had filed, with exhibit 10 being a letter from me to Paul Haas to the county, dated 5/23/23, which explains how this application is really being transformed from what had been previously presented to this board and what is no longer being presented to this board as a request for variances. You're not asking for variances. What I have indicated in my letter, yes, what I have indicated in my letter is that we are withdrawing the request for the variances, and we are using the materials that had been previously submitted as variances, but now we're using those, and our application is for conditional use status for the subject property with exceptions. So,
Can I just clarify?
Yes.
Are the exceptions, they're technically slightly different, but are the exceptions the same as
yes, sir.
indicated in the variation publication?
Yes, sir. They're the exact same thing.
And the theory is that we can go forward without a republication because this is a request for lesser relief than was originally published.
It is.
Okay.
It is. This is a request for a conditional use with those same exceptions, but now subject to further conditions. So it is a request for lesser relief that we're asking for. Exhibit 12 is a plat of survey for what would be after the assessment plat is approved. Would be what I'll call lot 1. It's actually parcel 1. And then number 13 is what would be parcel 2. I'm sorry, I noted on the cover sheet, number 13 being lot 1, that should be lot 2 assessment plan. And the reason that I have those two plats of survey for you is because they show in more detail what the exceptions are for that respective parcel. And then finally, exhibits 14 and 15 are letters of support. It's no secret, we've made clear that the purpose of all of this, this is a legal non-conforming parcel, and it has 2 buildings on it. On the parcel, it's a legal non-conforming use, and the effort has been to sell the property to continue to be used as is by new owners. Of course, we can't do that in the non-conforming status that it is. And so that gives rise to what it is that we're asking for. And so I do have letters from the contract purchasers, D&B Fabricators, written by Colin and Brian Markowitz, the owners of D&B Fabricators, and also by Roni Ajralia, who is the owner of House of Imports, which is also the purchaser of lot 1. What would be lot 1?
Who's going to testify to that?
Well, I have John DeYoung here. I was going to walk you through the exhibits so we could, I was going to walk you through the exhibits.
Well, who do we have to have sworn in?
Oh,
I'm
just sorry.
Maybe answer the questions or make a presentation.
Why
Why don't we get
Ryan, Colin, and John, please, if you will.
Wait, would you raise your right hands, please? You do solemnly swear or affirm that testimony about to give in this cause now hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
Thank you.
Yes.
So-
Mr. Roth, can I just take 1 second and sort of clarify the difference between exceptions and variations? Variations, of course, require the demonstration of a hardship, unique circumstance, or practical difficulty. It's my understanding that exceptions do not. And I want to, just so that we're all on the same page as we listen to this presentation, I'd like to have, is that your understanding?
Yes, it is, and I could properly speak to that by perhaps referring you to Exhibit 11. Exhibit 11 is what I've entitled the zoning application narrative. And I was going to go through some of the, well, explaining what it is that we're requesting in this case in a little bit more detail and cite to the support in the zoning code. But also toward the bottom, you can see that I've laid out what the exception standards are under the code.
Oh, all right, great.
And so to answer your question, Mr. Chairman, going to the bottom of page 1 of that exhibit, I expect that the evidence is going to show that the exceptions will satisfy the standards under section 1413.5 of the zoning code, which is for conditional use status. These exceptions are the same standard. They're verbatim, basically, what is laid out in the zoning code for variances, absent the points that Mr. Chairman, you just made. But if granted, the conditional use and the exception status will not, and these are the code sections that I'm referring to. 1, it will not impair any adequate supply of light and air to the adjacent property. That's set forth in section 1413.5, because no alteration or new improvements are going to result from the requested exceptions. So there will be no change in air or light. Turning to the next page. The exceptions will not increase the hazard from fire or other dangers to the property. Once again, no alterations or improvements are going to result from this request. Number 3, it won't diminish or have any effect on the value of land and buildings throughout the county. Same reason. 4th, it won't unduly increase or have any effect on traffic congestion in the public streets and highways. John can talk and Colin and Ryan can also speak to the extent of traffic that they will generate. But I would submit to you that the evidence is going to show that there isn't going to be any additional traffic from what there is right now. Next is that for the same reasons, because no alteration or new improvements will result, there isn't going to be any increase in any potential for flood damages to adjacent properties. Next is that the grant of the exceptions, the county, or there will be no additional public expense for flood protection, rescue, or relief. Same businesses that are there now. And finally, that the grant of the exceptions will not otherwise impair the public health, safety, comfort, morals, or general welfare of the inhabitants of the county. The site, both proposed parcels, both parcels are fully improved. And again, there is no intention, and I will represent to the county that there are no plans for any changes whatsoever in the existing buildings on the site that's shown on Exhibit 1. So I hope that answers your question. Yes, to that point. So the property now consists of the two parcels. They are referred in Exhibit 1 as lots. They have three separate PIN numbers. The entire parcel is approximately 2.29 acres with 198 feet of frontage on the north-south portion of Jeans Road. This property is 16 West 065 Jeans Road in unincorporated Lamont. It has 375 feet on the east-west portion of Jeans Road. Interestingly, Jeans Road takes a 90-degree turn. It doesn't change names. It's still Jeans Road. So on the north-south portion, there's 198 feet of frontage, and on the east-west portion, it's 375 feet. And you can see that in the Exhibit 2. I think that's perhaps that's the best plat that I have to show the entire parcel. Parcel 1 is 1.045 acres, and the parcel 2 portion is 1.246 acres. The entire property is zoned County I-1. And as I've said, each parcel is and has long been improved with one-story industrial buildings and is used for various uses allowed under the county's zoning code. And those uses, if you might flip to exhibits 4, 5, and 6, again, these are the street view of the property. You can see that it is a heavy industrial use, truck traffic. On lot 1, the House of Imports, it's for storage and sale of high-end automobiles, at least for the storage, and then the sales occur at other sites of House of Imports. So one other point is that Jeans Road was widened in 1992, and some of the exceptions that we're asking for are approval because of that widening in 1992, which has reduced the frontage short of the 40-foot required on both the north-south and east-west portions. And that has converted the property, I suppose, to legal non-conforming status as we speak today. Exhibits 7 and 8, these are aerials that I took off of Google, and they are accurate. But exhibits 7 and 8 are aerials of the subject property as well as the neighborhood. This is a very heavy industrial area with a lot of truck traffic all the time, and I think John can speak to this more particularly. But as you wind down Jeans Road off of 83, it's heavy industrial, and there's just truck traffic There's just a lot of it. That's what it is there. I'm going to now flip to, as I more or less conclude my initial comments, back to exhibit number 11, and perhaps I'm just going to read it, the first part of it, so I'm clear and the record is clear as to what it is exactly that we're asking for. So if you bear with me for a moment, I'll read the narrative on the first part of it. So the subject site, as I said, is 2.29 acres, zoned I-1, fully developed with 2 one-story industrial buildings. James Road was widened in 1992, and the site is legal non-conforming due to the setbacks. The applicant does not propose any new improvements or changes to the existing improvements. For purposes of sale, the applicant is applying to the county for, first, conditional use status under section 37-1001.4.c of the county code in the I-1 industrial district, with exceptions for the existing buildings and improvements described and detailed in the exhibits that I have referred to. Our request is for this approval subject to the following conditions. First, the standard zoning of appeals conditions that are standard to the board's typical protocols. Number 2, that the conditional use zoning relief shall be tied to the approved site plan. And again, when I refer to the site plan, I'm speaking of the improvements as shown in Exhibit 2, which is entitled subdivision plat. It will be our assessment plat, and it does show where those improvements are. I would also represent to the board that the exhibits 12 and 13 are what we had prepared as surveys for purposes of the sale, but they're surveys of what would be the parcel 1 and parcel 2. And the reason I refer to those is because they do more, they're easier to read, and they more specifically detail where the parcel lines would be and what the setbacks would be. So I would agree that the conditional use, that the second condition that I just referred to, is that it be tied to the approved site plan. I would suggest that that's a good approach, but I would also say to you that exhibits 12 and 13 could be incorporated as part of the conditions into the record, and I think that would make things clear. And then thirdly, that the third condition would be that all exceptions approved with the grant of the conditional use will be for the existing buildings and improvements as described in detail. And they will not in order to the future development or redevelopment of the subject property. These properties will be saddled with these conditions and with the buildings and improvements as is. No right to, if they ever wanted to change, they would have to come in before you and get approval in the form of a variance or something else. So they can't be changed. The purchasers of the 2 parcels, they know this and they have signed off on this. And so that's agreeable. And then finally, a condition I think that is attached to all of this is that this site approval will be by the approval of these specified parcels by assessment plans. Now, we're not here, I know, for plat approval, but I want to say that we are proposing and we are in agreement to the approval of the assessment plans being a condition of our relief. To be specific about what the exceptions are that we are asking for approval of are from the current yard setback standards under 37-1004 of the county zoning code. They are first a deviation or exception from the 40-foot required front yard setback, again, on both sides because Jean's Road was widened.
Which is the front yard here, Gene?
The front yard is the eastern side,
Okay.
for which for which there is a driveway coming in that divides the two buildings. So the eastern frontage is the front yard. Secondly, we're asking for the approval of a deviation or exception from the 20-foot required rear yard setback on the proposed lot 1 to allow that setback at 14.53 feet. The third exception is to allow parking in the existing 20-foot rear, 20-foot interior side yard on the proposed lot 1. And then lastly, a deviation or an exception from the 20-foot required interior side yard setback on the proposed lot 2 from 20 feet to 16.12 feet, which is what the setback is right now. So that's a lot. I think I've been talking, and I'm happy to try to answer any questions. And as I said,
Well, you didn't cover a couple of them.
okay.
So number 6 in the publication is lot 2 interior side yard from 20 to 15.
Yes. You know,
So is that in your narrative? I'm having trouble flipping.
no, that's not in my narrative, but yes, that is a request. And the basis for the request is the same as the basis for the other requests.
So just so the record's clear, all 6 requested variations are continue to be part of your plan and required by the current configuration.
Exactly.
Okay.
Forgive me for not mentioning that.
Okay.
But that's correct. And all of them are due to the existing conditions that are there today. And the condition would be that they not change.
If we convert, we're here on a Tuesday night because there's an urgency on the petitioner as to moving this case forward because of presumably something with your sale, and that's fine. We don't need to explore that. But can you tell me what your timetable is to get this done? Because I understand you want us to vote as soon as possible with a special recommendation.
Well, I do. John.
Well, just make the assertion, and I'm
Okay.
That's not a
The
extraordinary issue.
No, the issue is that prior to my even being engaged in this matter, there had been conveyance documents. The parties had entered into conveyances, and there is a limited time, and John can speak to the precise amount, but there's a limited time by which these encumbrances or any zoning issues have to be resolved. Otherwise those transfers can expire,
Right.
and the parties will lose their legal rights under those contracts.
All right, then I'm kind of skipping around here and getting ahead of myself. But there are only 5 members present this evening. We are meeting again on Thursday. I have no idea who's going to be here on Thursday, but we can only vote if we're present. As I remember the latest. Well, that's exactly where I'm coming from.
I'm sorry, James, I didn't hear.
Do these 5 members intend to be here Thursday?
Yes.
We're all in. Okay, so I'm going to take another poll in a minute because we may not need 7 if there are 4 who support this request, but we'll get that at the end of the hearing. Let me also ask you about when we add a conditional use, we often have some kind of a time limit. So often that's structured as this relief lasts for 10 years, and then you got to come back and request it again. I'm not suggesting that kind of a time limit because this is This has been there forever. And as you say, it's heavily industrial, but is it appropriate for us to put a time limit on effectively on your transactions so that we could say the relief expires in 2 years if the deal isn't consummated and the plat that you described is not recorded?
That would be acceptable.
Right.
If that's the board's
I don't know if it is.
wish.
I'm just sort of exploring ideas.
Yeah, what I would hope is that there not be a timeline put on the relief that then creates some uncertainty in the buyers.
No, I understand.
Mind.
I understand that. We're not going to ask you to. And that's not the kind of time limit that I'm proposing.
Okay.
This
transaction, the only thing that's holding up the transfer of deed is this. John, can you confirm? So when, if we can get the approval of the county board, if we can get your recommendation favorably and get the county board's approval, it's going to close.
Okay, so there's a lot going on here, and it is a little. I think I followed you with respect to what is essentially setback issues that exist today, and you were being asked to legitimize these pre-existing non-conforming uses. But otherwise, it seems relatively straightforward. There's no change to this property that is proposed.
That's right. There's no change
If
proposed.
there is a change, you would have to come back to request additional relief and.
Right, that's right.
Mercy of whoever's on this board in the future.
Well, and that's why I thought it was important to have Colin and Ryan here, because they're acknowledging that. Well, at least they could do so themselves if you ask them to. But they're aware of that. That yes, it is as is.
Sure. This is Colin and Ryan here.
Yes.
Can I just ask, you don't have to testify, but what part of this operation are they involved in? Is that the
So too.
and that's the car?
No, that's the welding.
The welding?
Basically what they, yeah, I mean, they manufacture commercial waste containers. And it's heavy industrial. There's a lot of welding going on. They bring in metal and sheet metal and put these together. That's the main portion of their business.
I want to indicate that there's no one in the audience that's not affiliated with the petitioner that we can permit to ask questions or make statements, but members of the board may have questions. So does anyone on the board have a question about what's going on, what's being requested? All right, now my only remaining point.
Mr. Chairman, can you speak closer to the microphone?
Oh, yeah.
Thank you.
You mean the new microphone?
Yes.
Super duper sophisticated microphone?
Yes.
My only remaining point is we heard this case once before and then it was withdrawn and republished. My recollection is there were a couple of other details in the earlier proceeding. So I'm toying with the idea of inviting you to take a position on whether we should adopt that record or whether this record is sufficient.
Well, I have no objection to your incorporating that record into this. What I would like to make clear is that concerns had been expressed at that public hearing. And those concerns then led to the change and are coming back under a new request for relief. What you were familiar with was basically the paperwork, the exhibits and the record that we had submitted at that time, and they are substantially the same. The real change from that record in this one is the narrative.
Yes, and the substantive sort of practical change is if this was brought as a and I think this was addressed at the earlier hearing, if this was brought as a variation request, you could do anything you want, unconditional in the future. So you restructured this so that we can put these conditions on that you've articulated.
That is correct. That is correct. And this ties it to no changes to the buildings and improvements.
Well, I think since that matter was fully discussed according to the way I recall it at the earlier hearing, I think there would be some benefit of incorporating that record. And a couple of members that are not here also raised that point. So it's kind of, it's my feeble effort to get their voice.
So I'll make the request then. I will make the request that the record in this matter also incorporate the record from
All right,
the previous request.
all right, we do that as a matter of course, so consider it done. Now, is there anything else from any board member? Then I think we're prepared to close the public hearing, but before it takes 4 favorable votes to pass a case with a favorable recommendation to the county development. If not indicating whatsoever how I feel about this, I always suggest that if we don't have the sense of the board that there are 4 favorable votes, that we kick the case over to a subsequent date when the entire board is here to give any petitioner the best chance for success. So do we have an inclination of which way we go here? Do either of you have any inclination that you're supportive of this case? Okay, well then we're done. Shall I close the public hearing portion of this and then move to recommendation? All right, that's agreeable to the board. So the public hearing is closed, the record is closed, and I would now like to open a recommendation meeting. Jess, do you have cheat sheets for us? Would you pass them out? I'd like to open a recommendation meeting on 23040 JB Capital Management LLC. And I won't read the request into the record again. So, Mr. Roth, wow. So conditions 12 and 13 you pointed out. Which exhibit was that on? Is that the narrative?
Exhibit 11 is the narrative, and then the bottom of page 1 of the narrative and the top of page 2 states the exceptions and states what I had read in as being our position as to how each of the standards for those exceptions are met.
But you indicated that a couple of conditions that you drafted, a couple of conditions 12 and 13. Where do I find those?
That's on them as well. And that, excuse me, that is on the top half of the first page where I have identified conditions 1 and 2.
Oh, yeah, okay. So, and then I have some proposals from the staff that have just been distributed. So let's take a motion on this case. Anyone care to offer a motion? I don't know who's talking. I don't know. It's Downers Grove.
Yes.
You want to make a motion?
Yes, I make a motion to approve, subject to discuss 1 to 5.
Okay. So we'll, is there a second to that motion? Zane, I apologize. I've forgotten your last name, but I have to say it for the record. Rahman.
Yes.
Motion by Mr. Rahman and seconded by Ms. Anderson. All right, now let's clearly articulate these conditions. The first condition is Standard zoning board of appeals conditions, which includes property be developed in accordance with codes and ordinances. Developer receives a building permit for any construction, which is sort of counterintuitive since there's got to be any. And then we have a proposed time limit that the conditional use will expire 2 years following the approval from the final approval from the county board in the event that the subdivision or plat is not, I guess not subdivision, but the assessment plat is not recorded. Then the structure, it'll also expire if the structures or use are destroyed by fire or other casualty or act of God to the extent that the cost of restoration for the above ground portion of building structures or use to the condition it was to the condition it was prior to the destruction or damage exceeds 50% or more of its replacement value. Next, that it would expire if the structures are voluntarily removed. Next, that all exceptions approved with the granted conditional use are for the existing buildings and improvements as described in the application, and exhibits will not inherit a future development or redevelopment of subject property. And I think those items repeat the ones that
Yes.
you included in your narrative. Okay, for the maker of the motion and the second, did I summarize the conditions according to your understanding?
Yes.
Okay, great.
Then are we striking number 4? The proposed ones?
Well, you know, that's one of our standard conditions, but as I said, when I read it, it's a little counterintuitive because the deal is if they build something else, this relief doesn't count. So,
Well, that's, yeah, then it's, if we accept 4 and your statements, we have a conflict right on the record. That's what
Yeah.
bothers.
so let's strike number 4 because, you know, you got to get building permits anyway. We put that in as a reminder in our standard conditions.
I wasn't worried about the building permits, but if we give them the right to do construction or excavation, this is premised on the existing building staying under this condition.
Yeah,
So if they tear it down and do construction, we've allowed it by our exception.
right. Well, okay, I agree. So I think we're ready to, is there anyone that wants to make a comment on or a statement about the case? All right, I think the petitioner has articulated.
One clarification, we've always said when it's a conditional use, it's conditioned on what's there and the people that are gonna do it. Are we conditioning this to the gentlemen that are here for their part of the building and who is ever gonna own the other building?
You mean like a tattoo parlor? We don't.
That person that opens it in a conditional use, if he's to sell it, if they were to sell their dumpster reconstruction to somebody else, does that go, does the conditional use go with them?
I don't think so, because we're not really talking about use here. We're talking about footprints of buildings. So if they were to revise their corporate structure to take on a additionally shareholder, I don't want there to be a technical violation.
And I will tell you that Colin and Ryan's father owns property adjacent and may have some or may sell to them some interest in the property or create a change, you know, without changing the building.
The condition, the reason I mentioned the tattoo parlor is we have a tattoo parlor with a certain person that we take exhaustive testimony from. We find them to be credible. We approve a tattoo parlor with certain hours of operation. And we want to make sure that's how it's operated. But this does not go to operation. It goes to the footprint of various buildings. And rationalizing this pre-existing non-conforming use, so I don't think we need that condition myself. Anybody else have comments? Then I think just in terms of the findings, petitioner satisfied the requirements and testimony was consistent with the requirements of the conditional use. Okay, call a roll if you would, please.
Member Roman.
Aye.
Member Anderson. Aye. Member Cutter.
Aye.
Member Moran.
Aye.
Chairman Carthel.
Aye. The motion passes by a vote of 5 in favor and none opposed. Good luck with your project.
Thank you so much.
Yep, thank you.
Thanks so much.